Disadvantages of forming a company. What are the disadvantages when we form a company? So first is formalities and expenses. So the incorporation or formation of a company is expensive. Okay. Second is there are too many formalities to be complied for formation and administration. Okay, there are too many formalities to be complied when we form a company or during the administration of the company. So this was the first disadvantage. Second is a company is not a citizen. Although it is a legal person, but it is not a citizen. It has only such fundamental rights which are for every person, citizen or not. The company has fundamental rights which are available for every person, citizen or not. There are certain fundamental rights which are exclusively for citizens, and there are other fundamental rights which are for everyone. Okay, so the company has fundamental rights which are available for everyone. The company has nationality, domicile and residence. The company incorporated in a particular country has nationality of that country. It cannot change nationality like natural person. So this was the second disadvantage. And the main disadvantage of forming a company is lifting of corporate wheel. This is an important topic. So when the persons behind using a company as a wheel or vehicle for undesirable purpose, the wheel will be lifted, the separate entity is deregistered, and schemes intentions of persons are exposed. So what does it mean? When there are promoters, members, directors, they form a company. Okay, the company has a separate existence. Okay, it is a separate entity. So the company is like a wheel means a curtain. Okay, like a mask or a curtain. Okay, so whatever these persons will do, they will do it behind the company, and they will do in the name of the company. The company will is like a curtain which is in forward of them. Okay, so the outsiders, they will deal with the company. Okay, when these persons, they use the company as a wheel or a curtain for their any undesirable purpose or any illegal purpose. Okay, in that situation, the wheel, this curtain, it will be lifted. Okay, and the separate entity, it will be deregistered, and the schemes and intentions of these persons, they will be exposed. So when this happens, in what circumstances it happens? First is when it becomes necessary to determine legal character of the corporation. What is the legal character of the corporation? In Daimler company versus Continental Tire and Rubber Company, it was like the company was registered in England, but the person in de facto control was the resident of enemy country, so the company assumed enemy character. Suppose the company is registered or incorporated in England, so it gets the nationality of England, it is an English company. During the war, suppose it was during World War II, at that time the Germany was an enemy country of England, and the company was having the English nationality, but the person who was in control of the company was a German national. So the court said that the company will assume the enemy character because the person who is controlling the company is of enemy nation. Second situation in which the corporate will be lifted, it is for the benefit of revenue. The company is formed for the benefit of revenue, like formed for only purpose tax evasion. The only purpose for which the company was formed was to evade taxes. Or the company is formed for fraudulent purpose, like there is a restriction on a person and he uses company to bypass that restriction. Suppose there is a person A, he has some restrictions on him, like he cannot manufacture defense equipments. Okay, so there is restriction on him. So to bypass this restriction, what he does, he incorporate a company or form a company, and through this company he manufactures defense equipments. Okay, so in this situation, the corporate the curtain of this company, it has to be lifted, and the real identity of the person has to be revealed. So there is a case law, Guilford Motor Company versus Horn. In this case, Horn was appointed as managing director of the company with a condition that while in office or afterwards, he will not solicit or entice customers of the company. Okay, when Horn's employment was terminated under agreement, what Horn did to bypass this condition, he started a new company, and through this new company he solicited the plaintiff's customers. So in this case, the court lifted the corporate wheel of this new company and said that the soliciting is being done by Horn, okay, behind the new company. So Horn will be liable for breaching this condition, for violating the condition. What happens in agency or trust, and in the case of government company, when any company is used as an agent or trustee or for own exclusive use, then it is not treated as a separate entity. Suppose there is a company, it makes a new company, and this company is used as an agent or trustee of this company, in or only for the exclusive use of this company. In this situation, this company will not be treated like a separate entity. It will be treated like a part of this company. Okay. The Supreme Court has said that a government company is not an agent or trustee of a state unless performing sovereign functions instead of commercial functions. If a government company is performing commercial functions, then it will not be treated as an agent or trustee of state. If it is performing sovereign functions, it will be treated as an agent or trustee of state. Wholly owned subsidiaries are not agent or trustee of parent company unless parent controls its activities in all respects. Suppose there is a parent or holding company and there is a subsidiary company. This subsidiary company is wholly owned. All the shares, all the ownership is with this parent company. If this is the situation, it will not be treated as a trustee or agent of this company. But if this parent company controls all its activities, okay, in all aspects, then in that situation it will be treated as an agent or trustee of parent company. Next situation in which corporate will is lifted or the separate existence is not recognized, it is under statutory provisions. There are some statutory provisions, there are some laws under which this corporate will is lifted. First is member reduction. Under section 45, it is said that if the number of members fall below statutory minimum members, like there are minimum members required to form a public company, it is 7, and for private companies it is 2. If these number fall below the statutory minimum and the company keeps on carrying the business for more than 6 months while below minimum, every member will be liable to pay company's debts contracted during that period. Okay. It cannot keep on carrying on, it cannot keep carrying business for more than 6 months while below minimum. If it does like that, then every member will be liable to pay company's debt. The company will not be treated as a separate entity, the members will be liable for it. Next is sale agreement. Under section 46, it is said that if all directors executed sale agreement in private company's name, the contract will not be invalid or illegal on the ground that no resolution was passed under section 48. Name misdescription. When officer of a company signs any contract, check or bill of exchange on behalf of company, if company's name is not fully or properly mentioned, in that condition officer will be personally liable to holder. Okay, if some officer is signing any contract, check or bill of exchange on company's behalf and he doesn't write full name of the company or not properly mention the name of the company, in that condition the officer will be personally liable, the company will not be liable. He cannot hide behind the company's curtain or company's wheel. In case of subsidiary companies, in certain situations, court may not treat subsidiary as an independent entity. Holding company has to disclose to members accounts of its subsidiary or subscribers. Like if there is a company, parent company, there is a subsidiary company. In normal situations, the subsidiary company will be treated as a separate entity. But in certain situations, court will not treat it as an independent entity, and the holding company has to disclose all the accounts of this company to its members. In case of fraud, like according to section 339, during course of winding up, during dissolution of company, during end of the company, if it appears that any business of the company was carried with an intent to defraud the creditors or any other person or for any fraudulent purpose, then those knowingly party to such conduct of business at the court's discretion, they will be made personally liable. Okay, during the winding up process, if it appears that any business was of the company was carried with an intent to defraud the creditors or any other person or for any fraudulent person, and then those who are knowingly party to such conduct of business, they will be made personally liable at court's discretion. Failure to return application money. According to section 69 clause 5, the director of public company is personally liable if application money is not returned within 130 days. if minimum subscription is not received or the company has not obtained commencement of business certificate. Okay, if the minimum subscription is not received or the company has not obtained the commencement of business certificate within 130 days, okay, in that situation the directors of the company have to return the application money back to the subscribers. Okay, if they do not do this, they will be held personally liable. In the case of misrepresentation is in prospectus, like there is a prospectus, there is some misrepresentation or untrue statement or false statement, in that situation there will be civil liability. In that condition, every director, promoter and every other person who authorize issue of such prospectus will be held liable towards those who subscribe on share on faith of untrue statement. If someone is there who subscribe on that share, okay, on the faith of the untrue statement, that prospectus, in that situation the directors, promoters and every other person who authorizes the issue of such prospectus, they will be liable to that person, to that subscriber. Ultra Vires Act, the directors are personally liable for acts done by them on behalf of company if they are ultra vires the company. What is ultra vires? Ultra means beyond and vires means power. If directors do anything which is beyond their power, okay, they do anything which was not in their power, okay, in that situation they will be held personally liable. It means the directors are personally liable for acts done by them on behalf of company if they do anything on behalf of company which was ultra vires the company, which was not even within the power of the company. In that situation the directors will be held personally liable. Non-payment of tax, if during winding up, if tax assessed for income of any previous year cannot be recovered, okay, if during the winding up process if the tax is assessed for income of any previous year, if that tax is not recovered, in that situation every person who was director at any time during that period, okay, that person will be jointly and severally liable. To punish real persons in quasi criminal case of company, there is a criminal case, okay, in that situation the court will lift the wheel of the company, okay, it will lift the corporate wheel and see who is the real person behind the corporate wheel who has done that criminal offense, and the real person who violated the law, he will be exposed, and he will be held liable. Next is to prevent abuse of process of law. Lifting wheel principle available in Companies Act, other finance and tax statutes. Courts can use in other situations also to prevent abuse of power. It cannot be monopoly of any particular statute. Okay, so what does it mean? The principle of lifting the wheel, okay, to remove the curtain, to remove the wheel and to expose the real persons, to help liable the real person, it is available in Companies Act and other finance and tax statutes. And if there is some person A and he knows this and he thinks that he this principle is only available in Companies Act and other finance and tax statute, and he thinks of any other act in which this principle is not available, and he abuses that act, or he abuses the process of that act and thinks that the principle will not be applied here, the reality is not this. The courts can use this principle in that situations also. The courts are at its discretion, it's not the monopoly of these companies, of these acts only. The courts can use it in any situation. Okay, so this is to prevent abuse of process of law. The person was thinking he can abuse the process of law, that this principle is not available in other acts. Okay, the situation is not like this, the courts can use this in other situations also. So these were disadvantages of forming a company. First was formalities and expensive, okay, too many formalities and it is expensive. Second was company is not a citizen although it is a legal person. And the third was lifting of corporate wheel or corporate curtain. Okay, so these were the disadvantages. For revision purpose, if you want this PDF, you can get the download link in description or comment box. Next topic will be kinds of companies, which we will cover in next video.